then turn it into a sergeant or to the clerk. All right, will the clerk please call the roll for today's attendance?
Chair Wozniak,
Here.
Representatives Johnson,
Here.
Forts,
Here.
Farhat, Brenda Carter,
Here.
Senators Wino, Bayer,
Here.
McMorrow, Tice,
Here.
Runstead. Mr. Chair, you have 6 members present.
All right, we have a quorum. All right, little administrative work we're going to get done before we start taking testimony. Rep. Johnson moves to adopt the minutes of the May 7th meeting. There being no objection, the motion prevails by unanimous consent. Rep. Wertz moves to adopt the minutes of the May 14th meeting. There being no objections, the motion prevails by unanimous consent. Rep. Carter moves to adopt the minutes of June 11. There being no objections, the motion prevails by unanimous consent. Yes, I'm there, yeah. Senator Runstead moves to adopt the minutes of the September 3rd meeting. There being no objections, the motion prevails by unanimous consent. Okay. As a reminder to committee members, any action by the JCAR committee shall be by concurring majorities of the members from each house. That means 3 representatives and 3 senators must vote in the affirmative on any motion for that motion to prevail. Today, we'll hear testimony on JCAR Rule Set 2549. We'll begin with Aaron Shore from the Department of State. And if you take the chairs here, and I'd also like to call up Rep. Smith and Rep. Boland. And you can take those 2 chairs there. Thank you. The reason I'm calling up all these people at one time is so that you can ask questions to either side while they're here. We're under a time constraint for them being here. So after the Board of Elections, Bureau of Elections gets done, then I'll have Rep. Smith and Rep. Boland testify, and then we'll ask questions, okay? All right. Ms. Shore?
Thank you, Mr. Chair. Thank you, committee members. It's good to see you again this morning. I also have Adam Fracassi here from the Bureau of Elections, who I'm sure you remember as well. Thank you for having us here today to talk about the rule set on the use of electronic poll book. As some of you may be familiar, and Adam will get into more details, we have historically in Michigan, at least in recent memory, used a poll book that had to be downloaded onto a laptop in the election day polling site. With early voting, we needed some different functionality, and clerks were very supportive of the connected poll book that we offered for early voting and encouraged us to look at whether we could make something similar available for Election Day in places where the technology supported that. And so that is what we have looked at doing with this rule set. We've been working since earlier in the year. Initially reached out to clerks for their feedback on our draft language before the draft rule was even submitted for the formal rulemaking process. We shared the language with a variety of news outlets in June in advance of our public hearing on July 1st, as well as several other listings that we typically send information to, and received 2 public comments at that hearing, both in support of the rule, no comments at that point in opposition, and so we're able to move forward with putting the rule in front of all of you. And I'll ask Adam to walk a little bit more through the rule itself and what that does.
Good morning. Thank you. Good morning, Chair Wozniak. Thank you, members of the committee, for having me here today. So as Aaron said, my name is Adam Fracassi. I'm the Deputy Director of the Bureau of Elections. So I want to start with just the starting point as to why we're doing this. So as Aaron indicated, this largely is in response to Proposal 22-2, as well as the implementation of the electronic poll book that we developed for early voting. So in 2024, clerks administered 3 statewide elections using the early voting. We piloted the early voting poll book in 2023 with a select number of jurisdictions as well in the November of 23. election. And following those elections, we convened what's a lean process improvement workshop to identify the different successes, the outcomes. We coordinated that with the Department of Technology Management and Budget, and sent a survey as well to over 350 clerks, their staff, and received a lot of feedback from the clerks on the poll book itself, the ways that it could better be used for them, and the ways that it could better make their job easier, quite frankly, when it comes to processing the voters in the polling place. So the overwhelming recommendation from the clerks and the LPI was that clerks wanted to use the same poll book that we developed for early voting through Election Day. Mainly because it's functionality, it's easier to use, it's easier for the poll workers to be able to work through. So clerks overwhelmingly wanted us to develop the poll book for Election Day. So what the rule itself does is clarify the language in section 668B as in boy, which says that the poll book must be downloaded by 4 p.m. the day before the election, subject to a caveat for certain jurisdictions of certain sizes. So what we're doing is clarifying that piece to specifically say what the download is versus how it works, what the download will be able to be used for versus a live connected poll book. So clerks are able to use that version, the EV-EPB version, on Election Day as well. So it expands on that. Historically, that section's always been understood to, as Aaron said, to mean that software is downloaded to the electronic poll book laptops that are provided to the clerk's offices, and it operates offline on Election Day. But that, again, this rule is aimed at clarifying that to incorporate that. With the implementation of early voting, like Aaron said, we had to develop a new poll book for early voting altogether because the one that was already developed wouldn't function with the early voting structure. So the poll book that was developed for early voting had a direct connection to registration lists and statuses, ballot status in the qualified voter file, not the entire piece, just very limited parts of it, in order to effectively and efficiently and securely administer the early voting days, whether it was the minimum of 9 days or the jurisdictions that were doing more. And the reason that connection was important was so that way we'd be able to tell if someone voted in one place on day 9, you were able to just have their voting history done. They were done. They cast their ballot. We're done. We're able to track that across jurisdictions, across early voting sites within the same jurisdiction in particular. So what the rule does is essentially first, it codifies existing practices when it comes to the poll book itself, with the exception of this connection to the qualified voter file for Election Day. So the rule says that the poll book must be operated by a secure live connection, presuming there's internet access. Notably, we do not mandate use of this poll book because we recognize that there are some jurisdictions where internet access on Election Day is a challenge. We're lucky with the early voting sites. It's one of the requirements for an early voting site to have a stable internet access, but you have less regulations you have more flexibility, I should say, on an early voting location than you do on Election Day because of the precinct sizes on Election Day versus a county-wide site, for example, in the early voting window. So that's kind of the starting point, is we're just making this an option for clerks if they want to use it. If they do want to use the poll book, it has to be a secure live connection subject to the security requirements that we've developed in conjunction with the Department of Technology Management and Budget. And clerks still have to download the poll book to serve as the backup. So if something happens, if internet goes down, something happens, there still is that paper backup for clerks to be able to process. Power goes out at a polling place. Things happen every day, on every election, I should say, that are often unexpected. So the download serves as that backup now still. We still encourage clerks to also have a paper backup, again, for those same reasons. So that way you've got kind of a double protection there. The rule also clarifies the reports requirements. It clarifies what is to be done after Election Day with the poll book. Currently, we require the poll book be uploaded, the data be uploaded, and the poll book be uploaded to the qualified voter file 7 days after the election. So this puts that into the rules specifically. And the reason for that is so we can accurately capture voter history. We can do the post-election work that our office needs to do in order to close out, to conduct the audits that we need to conduct, for example. And the rule puts that into place specifically and says the clerks have to upload it. One of the benefits with the live connected poll book is that there's no upload then that's needed because the data will automatically come through to us, so the clerks don't have to take an additional step. It will just automatically come through. But if you're not using that live connected, then you have to manually upload that data to us so it can be preserved for the applicable time periods under state and federal law. It also would just clarify the records that are available, clarifying and making sure that it's clear that the data that is there, the voter history data, all of that information is available under the FOIA as is existing practice. But the underlying security components, the programming, for example, the code of how we build is not subject to FOIA for security purposes. And like I said, essentially it put into current effect, codified current practice, when it comes to just the release and the processing of the poll book and the download. So that's overall at a high level what the rule sets do. And with that, I'm happy to take any questions or pass it over to Rep. Smith and Rep. Bolin, however you would like to.
Yeah, like I said, we'll hold on questions until all the testimony from these people is completed. Rep. Smith.
Thank you, Mr. Chair and members of the committee. It's good to be here. And I also am the chair of the House Committee on Election Integrity. So I would just appreciate coming before this committee and expressing my strong opposition to this proposed rule set, which completely will circumvent the legislature to take power away from the local clerks and hand it to MDOS. Under this rule set, clerks must upload the voter history files from the electronic poll book to the qualified voter file and then delete the electronic poll book software and associated files by the 7th day following the final canvass and certification of the election. What this means is that all sensitive election files will leave the hands of the local clerks and be placed solely under the control of the state. MDOS is thus increasing its own power and diminishing that of the local government oversight. As you all know, our elections are held here at the local level. The clerks have that information, and I think it's important for them to retain that information per FOIA, which has been discussed that this is FOIA-able. Not only is this rule set a power grab by MDOS, but it's also a lawsuit waiting to happen. Federal law under the Civil Rights Act of 1960 requires that all records of voting history and other required files, including electronic records, be preserved and retained for 22 months. But under this rule set, clerks only retain these files for 7 days. Once that upload is done, it needs to be deleted, and it's no longer in their possession. So, if MDOS has the right to retain these documents for 22 months, then so should the local clerks and jurisdictions that are conducting these elections. So this rule set, in my opinion, is just yet another example of MDOS expanding its power to bypass the legislative process. I argue that it is essential for Michigan elections to be governed by laws passed by the legislature and not by expanding rules through promulgated by the State Department. We have seen this over and over, and it was previously even mentioned how they're trying to codify things, and it's just, we have to keep this to where the legislature is the one that is determining the laws within our election process. So just wanted to say that. Thank you for your time and listening to my testimony this morning.
Thank you, Rep. Smith. Rep. Bolin.
Good morning, Chair Wozniak, members of the committee, and birthday gal, Representative Carter. Happy birthday. Thank you for the opportunity to testify on this proposed rule set. As a former clerk, I stand opposed to the rule set as presented. Michigan, once known for having sound election law that had the necessary checks and balances at every stage of an election, has been stripped of many of these checks and balances over the past 6.5 years under Secretary Benson. often by directive, not statute, or rule as required and as expected, and sometimes even the courts have seen this. We've seen these directives, practices taken to court and ruled in favor of the people of this great state. Public confidence and trust in government is at an all-time low. Our elections are the people's voice. If we do not have election integrity, we do not have a voice. That is why I stand in opposition to this proposed rule set that would allow for the destruction of election records at a critical point in the election process. As a former clerk responsible for all record retention in my community of almost 20,000, a high priority in preserving trust, providing records as needed or requested, is only as good as the ability to retrieve the necessary documents or records. That is why I oppose this rule set that would allow for the destruction of a key element of our election process at the local level, the electronic poll book data. While the information does get transferred to the QVF, it is essential that we instill trust, confidence, and a record that is retrievable. My opinion is that these records, as with all election records, should follow the federal retention requirement of 22 months. We should not part and parcel our election records. I also stand before you today with concerns about the electronic poll book access at polling locations. While it's optional, I don't think we want to create a situation where it's different around different parts of the state. It creates a lot of chaos. And in a state that still suffers from reliable internet access and where our incredible poll workers work only 4 elections in a year at best, we need to ensure the communication and decision-making is done by the elected or appointed clerk, and that access is secure, timely, and adequate for all needs. I urge further consideration of this retention period and internet access at all polling locations until further rationale can be given to ensuring the security, access, and assurance that the election has been administered properly, there is confidence in the results by all, and all post-election activities are fully completed. Thank you.
Thank you, Rep. Boland. As I stated earlier, we'll open it up for questions. I'll ask the first question. Adam, what is the reason for the 7-day destruction of the poll book?
So I want to clarify that piece in particular. So when it comes to the data itself, so the starting point is everything has to be printed. So none of the data is lost at the local level. Everything out of that poll book has to be printed, and it is maintained in a paper form at every single jurisdiction. That is already state law. That's already required. So that is also echoed in the rules as well for that exact reason, to clarify that piece of it. So the second piece is that 7 days comes from just practice that has been done for decades by the Bureau. And the reason for that is because it, again, gets uploaded into QVF, it gets printed out and retained by the local. That the jump drive itself, that stick itself, is needed for future elections. Otherwise, clerks have to buy new equipment. They will have to buy more, which they don't have the ability to a lot of times. So that's part of why. And the other piece I want to clarify is that it's not mandated to be immediately by 7 days, because if there's a pending recount, if there's a pending issue, if there's a pending audit, if you're selected, then you can't delete anything on that from that while that recount audit or if there's a court issue, for example, is ongoing. And the second piece with the deletion as well is even if 7 days elapses and we or the county clerk have not released security, that cannot be deleted as well. And the rule specifically says that too, to say everything has to be preserved. The earliest you could do it is 7 days. That happens in very limited circumstances where within that 7 days, security is released, there's no issues. I'm thinking a special election, for example, in 2024, where the turnaround time between the primary and the general was very tight between the county canvass and when they needed to start programming for the November election, for the general election, I should say. Excuse me. So I just want to clarify that piece. So again, it's not being deleted altogether. It's being maintained in the paper form. It's not allowed to be deleted until after security's been released, which includes making sure that the paper copy and the QVF upload has been in place. And that's also the reason why we have put in here specifically that mandate that you have to preserve the electronic information as well, that electronic data. And that is, we've done that through QVF as an ability to allow clerks to be able to use the equipment.
So I'm still curious about why are we deleting the ebook after 7 days?
So you're not deleting any of the data, to be clear.
Right,
All
okay.
of the data is preserved in those two different ways that I mentioned. So the 7 days comes, again, just because the stick that the poll book software is on is needed for the next election. Clerks need to be able to use that. So that's why we say preserve it in these two ways, and then you can take the software off of that stick so you can use it to download the next poll book data, the next poll book lists, all of that stuff for like the November election, for example. So if you're in that August-November period. So that's why we say it's moved basically from the stick to paper and electronic elsewhere.
Okay.
If I could just follow up, to just say, yes, there are records, as you mentioned, that you are printed, but that is minimal compared to all of the things that are on the stick itself. So while you say, I mean, you have your ballot summary, the voter history, et cetera, and how a person voted may be printed, and you have that, but you don't have all of the necessary stuff in the event of an audit or for FOIA information reasons. The other thing is, these sticks are not expensive. So there's no reason that we cannot have additional of these sticks for each jurisdiction. I think that's a poor argument when the cost of these are not very much.
So I would just like to echo Chair Smith's comments about the importance of this. What we are doing, we are talking about the e-poll book on a flash drive. That is the record, all right? Being transferred is like having a carbon copy of an original document, all right? We're copying it to the QVF, we have a paper copy, and you still may want to maintain the original. That's what we think is in the best interest of the elections across the state, is to do that. These discs are not, and I would say that the Secretary of State has been sitting on election security grant money, and this would be a very notable and logical use for that money, is to supply all of our clerks across the state all of the flash drives they need. Remember, early voting is only required in statewide and federal elections. It's not every election. And while I would say in the importance of this, and we do have to revisit our guidelines, our practices and whatnot, then why was the Secretary of State's office so late in delivering e-poll directions, including destruction, retention, and how to properly use them, the Saturday before we started with the presidential election? All right, so it just seems like we're always coming after math. Why don't we start thinking ahead of time in these prevention, and to squabble over this and destruction of the records leads me to believe that there's some other nefarious reason to do it. It's a very simple thing to provide to the clerks. They are their records, for them to maintain them for their purpose as the local administrator. And I do think it's a clear overreach of the Secretary of State's office to be seeing that they're going to be our record keeper from now on. I think this is really a push to try and take more and more election responsibilities and duties away from the local clerks and the county clerks. And I remain objecting to these rules.
Adam, about the sticks, are they proprietary, or are they available at Best Buy or anyplace else?
They can be purchased, but so what I would say, I guess, is yes, they can be purchased. You would need one per election. You would need one per precinct. So that does come at a cost, and it's not something we can use security funds for a variety of the regulations that the federal government's put in place on it. So
The legislature could choose to provide funding for it, though.
Yes, we could. Yeah. Rep. Wertz.
Thank you, Chair. I find these rule set changes very intriguing, as I represent Hillsdale County, and you're probably well aware of the lawsuit that's pending there. And actually, these seem a bit contradictory even to what your, I believe it's Mr. Barber testified for, that they are required to keep the records for 22 months federally, and that they ordered our local clerk to dispose of those records. So a bit of a contradiction that occurred in court there in Hillsdale. But specifically to this, I guess, how much do the flash drives cost?
I don't know that off the top of my head.
It's a normal flash drive, right? Is there anything special about these flash drives? So a flash drive's about $5, okay? So we're talking about $5.
I think it's a little bit more than just a regular flash drive because of the volume of everything, but if that's information that we would like to provide, I'd be happy to get that information.
Okay,
and
so
see.
let's say 10, we'll be generous. I've bought many flash drives,
And
so.
I would reiterate that it's one per precinct, so in a larger jurisdiction, that does add up.
Yeah, I've worked elections, so I mean, we're not talking a whole lot of, I mean, we have a budget of proposed 83 billion, so I think $10 per flash drive kind of seems a little, that you want to destroy these as a cost-saving measure seems a little contradictory. But I'll continue. Do you know what the requirements for how long you have to keep records? The state sets out requirements. I was a conservation district manager. I got all of these guidelines for how many years I have to keep records. Do you know what that is for townships, for various other data, and I would say, I guess, things that need to be preserved?
We could speak to the state requirements for election. I can't speak to what a township's retention record is for any other type of data.
Okay, yeah, Secretary of State, speak to what your requirements are for some of the other preservation.
So it really depends. So there are record retention schedules that are developed by DTMB. So I guess I would ask for a little bit more specificity because there's a whole schedule for every different type based on state, based on requirements. So I guess I would ask for a little bit more specificity.
Okay, sure. Let's talk election stuff. Let's talk ballots. Let's talk records of identification. What's the rules for that?
Two different. So four different, actually. So if it's a state and federal election, it's 22 months. If it's a local election only, it's 30 days for ballots. For the requirements, for the ID requirements, it depends on what depends, because some of the applications are 6 years, some of them are 2 years. So it just really depends on the specific document. That's what it's governed by. So, and I will say that there's also a statute that's set under an existing statute as well that authorizes documents to be preserved electronically versus only in paper, and that count as the exact same thing. So that all kind of plays together, and that's all the DTMB side of things with the record retention, the History Center Act, the Electronic Reproduction of Records Act, and et cetera.
Okay, so what else only requires 7 days of preservation?
So to be clear, this is not requiring only 7 days of preservation. Again, this is being printed and it's being maintained for 22 months or 30 days. It's being uploaded into QVF. All of the data that is on that jump drive is being uploaded into QVF and is being retained as well.
But where's the accountability and the checks and balances there? So you're saying it's being uploaded here to the state, but where's the accountability for if there's questions or there's contradictions that at the local level that can be referenced, especially if there's a recount? And if you're saying 30 days, so you're requiring 30 days minimum for anything else, but you're saying get rid of this after 7 days.
But again, we don't do that until security is released. And if there's something pending like a recount, we would not authorize destruction.
In the rules specifically.
Why
say-
wouldn't you at least do 30 days in your rule set is my point. Why are you making this 7 days if at a minimum you have to keep records for 30 days, then make it 30 days.
The
Why-
information is being retained, it's just being retained in other
No,
ways.
but it's not a checks and balances, and we all know, let's look about the data breaches that have occurred. My kids were in school when they couldn't go to school for multiple days because there was a hack and the Jackson ISD. This happens all the time. We passed legislation yesterday preserving and putting laws against people who are stealing and then embezzling money through gift cards. I mean, we are rampant. How many of us got texts saying we owe fines to the state of Michigan and we don't even have tolls? And you guys want to get rid of something after 7 days?
Shouldn't the paper copy be more secure against a data
It
breach?
should be, but we should have both. And we should have a minimum of 30 days if 30 days is what's required for everything else. Thank you.
I just want to clarify that, the disk is a separate item. It's just like having a paper copy, you're saving the flash drive. So, the breach could occur by having everybody have internet access across the state if it's not secure, which should be a very, very big concern for all of us. But that flash drive is, I think, what we are encouraging, that should be retained for the 22 months. And there may never be a question, but why would we destroy it in the event there potentially could be a question? It's very simple, 4,500 precincts across the state roughly. In absent voter counting boards, like at $10, it's not a high number.
Senator Bear.
Thank you, Mr. Chair. I just want to really just to be clear, when the data is uploaded, is it everything?
Yes.
Yes. And when it's printed, is it everything? What's missing from the print?
The print contains all of the voter data specifically. So what would be missing from the print copy would be the underlying metadata, which is preserved by the upload in the QVI.
It's in the upload.
But that's just, yeah.
Okay. So it probably is maybe $100,000 for all 4,320 precincts that we have. Maybe.
It
Madam
might,
Chair, can you help with this?
Absolutely. I think that the Michigan Department of State has money within their budget that they could easily use to pay for this.
We do not have authority to spend any of our existing funds on this purpose.
It's a big enough number that we might need to actually put it in boilerplate somewhere and make sure that the funds are there.
Duly noted. Thank you.
Thank you, Senator. Rep. Carter.
Thank you, Mr. Chair. And this has been a very informative discussion, but I want to focus on the actual mechanics of what you're trying to accomplish. And specifically after visiting the Keweenaw Peninsula and witnessing the fact that internet insecurity was a big issue. The only question I want you to just really deep dive for me is to tell me what is the outcome of what you're accomplishing. I can see everything clearly of what you're doing, and the cost factor could be negotiated, a boilerplate, etc. But the true outcome of this rule is to provide efficiency, I believe. And could you just do a deep dive for me to help me understand, without the nuances, what you're trying to accomplish?
Sure, I'll try my best, and please, if I'm not explaining something, please interrupt me. And happy birthday! I can't think of a better way than to spend it. So I was being completely serious. I love this. This is fun. I'm honestly completely serious. So what we're trying to accomplish here, the biggest thing. Again, when I talk about like that feedback that we heard from clerks, it's the ease of the use of our EV EPB that was developed versus the poll book that was developed with election day, the election day poll book. The election day poll book was developed quite a little bit ago especially in terms of technology. It's still relatively recent, but with just how fast everything changes, people are used to ease, right? So the EV EPB that we developed was a lot easier for people to use, number one. Number two, the early voting EPB also gave us better ability to, like I was talking about with that connection. One of the benefits that it being connected live in that secure way is that it's able to detect voter movement and voter pattern, in the sense that if with early voting in particular, if your Oakland County, for example, who has 18 county-wide sites across all of Oakland County, once somebody shows up at one site, it's recorded in the poll book at every site. So that way, you're able to prevent any sort of bad actor from going elsewhere, or even jumping from Oakland to a different county if they're eligible, things like that, because it will automatically be recorded into the poll book itself. So by expanding that into the election day as well, you're also bringing that additional layer of security into the election day poll book as well. And then the final piece is consistency for poll workers. Right now, clerks have to train poll workers on two different poll books. You've got to train them on how to use the early voting poll book and train them on how to use the election day poll book. What the rules are designed to do is allow us to just use that early voting poll book throughout. So that way it's all consistent for the poll workers as well. It makes it easier for them. They're used to it then, and there's not that separate level of training. It minimizes confusion for poll workers on how to set up the poll, on how to process it, how to process voters as well. So those are, I would say, the kind of like at the high level, the three things that we're trying to accomplish with the rules and the three outcomes. And
again, it wouldn't be mandatory because we understand there are jurisdictions, like you had in the Keweenaw, who just can't take advantage of this yet, and until we're able to do something about making sure we have more reliable internet in every corner of the state, which will be helpful for so many other reasons. But,
Okay, I definitely was gonna go right back there
Yep.
with
Yep.
the internet insecurities statewide, not just in the Keweenaw. So I think you've answered my questions.
perfect.
If I may
Senator
just add,
Runstead. Oh, I'm sorry.
then
Rep.
maybe
Smith.
under that thought, why wouldn't we not mandate that it be deleted after 7 days, and that the local levels can retain that? Just a thought.
Senator Runstead.
Thank you. I'm just curious how the 7-day requirement does not violate federal statute 52 U.S. Code 20701, which demands that materials associated with federal elections be stored for at least 22 months.
So like I said, it is being stored. The data is not being deleted. It's essentially being moved, is what I would say.
So because it's done on the paper, you're saying that qualifies as the materials being preserved.
So it's being preserved both on paper and by being uploaded into QVF.
Thank you.
Thank you, Mr. Chair. I have a few questions. So I appreciate what you're saying, but in my extensive research and trying to dig deeply into what's going on here, we found extraordinarily difficulty in trying to get access to what the Secretary of State was holding unilaterally. We were prohibited from getting that, and none of the documents that were provided to us were searchable. So if what you're doing is sending it, I shouldn't say none, sorry, many of the documents provided to us were not searchable. If it's going to paper, then how is Susie Homemaker, who's FOIAing something, supposed to be able to find what she's looking for, did this person vote, without going page by page by page, if the access isn't being given by the Secretary of State?
So a couple of things. So if you're looking for information on whether or not a person voted, so that voter history, the benefit of having the connection as well is it would allow our office to be able to provide that information. We provide voter history. We provide that information on a regular basis to folks that request it under FOIA. So do the county clerks, so do the local clerks. Local clerks and county clerks are also able to pull voter history and voter registration information for their voters, so under FOIA, so they'll be able to provide that information to somebody requesting it as well. And then, so that would include if I vote in the upcoming November election, I live in the city of Lansing. The fact that I vote in the upcoming election's public information, both in the paper version, that folks could go in and look through the paper version if they want, but you're also able to just say, did Adam Fracassi vote, and what elections has Adam Fracassi voted in? I want his voter history. You can get that from the Lansing City Clerk, the Ingham County Clerk, or from our office. You can get it from any one of those three.
If I might continue? Yes. I was prohibited from getting a direct snapshot of all of the registered voters on Election Day and told that that wasn't accessible. Again, relying solely on the Secretary of State, obviously that would be extraordinarily difficult to pull individually from all of the local clerks. Is that corrected in this process?
So I don't know what you, I guess my first question would be what specifically you asked for. So if you asked for QVF has the ability to provide voter history, but if your request was, can we have an exact copy of the registration list as it existed in November of '24, QVF can't provide that.
Why not?
It's because of just the way the registration list works. It has to be living. It doesn't provide like that snapshot in time.
I find that unfathomable. Sorry, I have one other. So you don't have a record retention. I understand it's beyond 7 days after you get done with all the other stuff, but you don't have a record retention within your office of 7 days for other documentation.
Not that I'm aware of off the top of my head that would allow us to destroy without preserving in some other way like we're doing now. What existing law would allow us to do is, like, if we get mail, for example, we scan that, we make that a digital copy, I can destroy the paper version of the mail and keep the PDF as long as I've double checked to make sure it matches, which I would equate to basically what we're doing here.
And then lastly, this document speaks to what information is FOIAble and what isn't, generally with giving statute instead. I recently read about the DOJ requesting information of our Secretary of State that they were prohibited from receiving because it was not publicly available information. Can you explain to me what information they were prohibited from getting from our voter files?
I think we could locate the letter that was sent to the DOJ and provide that to you.
I would appreciate that. Thank you. Thank you, Mr. Chairman.
Thank
Mr.
you,
Chair?
Senator. Rep.
Mr. Chair?
Carter. Oh, I'm sorry.
I do have something
Rep.
that I
Smith.
would just like some clarification, if that's okay, kind of related to Senator Tice's question too, if the department could help clarify this. So under the FOIA, when there is, you know, all the voter history and such, when somebody wants to request that, has the field of the method of vote been removed for these FOIA requests, such as in-person, early voting, or absentee?
So the method of voting, those 3 ways, is maintained within the qualified voter file. We currently do not provide that under FOIA because of the risk to jeopardizing voters' secrecy and their right to a secret ballot. Namely that with how our elections are, how our results have to be provided, with it being broken down by jurisdiction, by precinct, by candidate, if you have jurisdictions, which we have many, where you have 1 or 2 voters showing up in one of those ways, if you have only one person that returns via AV, or they vote via Election Day or EV, if only one person in that precinct, what happens then is once you put the results out and you've got the results broken down by method of voting, combining that with the precinct plus jurisdiction plus the method would allow somebody to very easily tell who that person voted for. So we currently are not providing that. We remain open to trying to find a way to do it. We've not been able to successfully figure out a way to release that data without violating Michigan's Constitution.
I'd be curious to know which precincts have only had one person.
We can
That would be helpful information to have, because this is something that has recently changed just this year, that they've removed the method field under a FOIA to know. Thank you for explaining that. I just find it hard to believe that we have a single voter in any one of those at jurisdictions across the state. Thank you.
Rep. Carter.
Thank you again, Mr. Chair. You know, this is really coming across to me as a consumer protection rule, okay, something that actually protects our consumers. You can explain to me, if it isn't, let me know, but if it is, can you tell me how it protects the consumer's right to vote?
So, yes, in general, yes, I agree with that, with the consumer being the voter, right?
Being the
So,
voter, yes.
I want to.
Got insurance mixed up with it.
No, all good. I understood what you meant. So I want to clarify. Do you mean the rule set itself, or the answer that I just gave, or
Both?
Both. Okay. So
Because- let me just
Yeah,
explain, because I work very hard to mitigate consumer misinformation, the whole 9 yards, their voter rights, and making sure. I've heard various segments throughout here where you can almost instantaneously identify if a voter has voted here or voted there. Is it something that this rule set is doing to help our constituents in their voting with their voting rights? That's what I'm asking.
Yeah, I think there's a number of different ways. That's the pause. I'm trying to figure out how to succinctly say it, to be frank. So I think there's a number of different angles with that. So regards to the voter themselves, and really this is kind of like all through the clerk's office and through the workers themselves. By, again, kind of like what I said, having a better functioning poll book protects the voter's right in general. Having a better functioning poll book that is more usable by everybody, like the poll workers, it's more easily for them to use it. It's easier for the data to be maintained and preserved in those multiple different ways. I think that in general, that's a better. I'll pause because yeah, please.
Okay, yeah, I'm asking for accuracy.
Yep.
Okay, that's what I'm asking for.
And I think as Representative Bolin has alluded, and we've said also, we're so appreciative of the work that our election day volunteers or, those workers put forward. But it is something that they only do a few times a year. And sometimes they're folks who are maybe getting on in years. And so anything we can do to simplify that work for them, I think really leads to a better run election. So as Adam mentioned, having a consistent poll book between early voting and election day will help with that. And also that was certainly the feedback that we got from clerks and election workers through the lean process improvement process was that the connected early voting poll book that we had was much more user-friendly and so it helped to run a better election.
So you could follow it, please. So you could actually say what you're proposing would actually make our poll workers' jobs and the whole system more efficient.
Absolutely.
Thank you.
Rep. Bolin?
Well, thank you. I guess I would just object. I don't think that the retention of the thumb drive has anything to do with easing the poll worker's job in any way. I will echo and fully support having consistency across the board. We should not have a different rule for this kind of polling location and this polling location. I mean, it's very hard as one former clerk and one who used to train election workers. There's a lot to election law as it is, and just to create these inconsistencies with programming. But I would say, Rep. Carter, the number one thing we can do to protect our voters is to have photo ID and verification of U.S. citizenship. That is what will protect our voters.
Rep. Johnson?
Thank you, Mr. Chair. Identifying number and timestamp. Does that come out on this summary piece of paper? Where is that preserved?
I believe, I would have to check, but I believe that is in the QVF. It's part of the download it's part of the upload that goes in that we have the ability to see.
But could be potentially lost if we're deleting information?
No.
Yes?
No, because again, by uploading it into QVF, it's preserved. It's not being lost.
Both of them?
Yes.
Timestamp.
I'm almost positive.
And then, is there a reason we're not putting this through the normal legislative process and we're going through JCAR to fast track centralized control of the elections?
I would say this is a normal process to go through. There are some things that change what is in statute, and so we need to go through the legislative process. And then there are other pieces that are merely interpreting the existing statutes, which we can do by rule, and this is one of those items.
It's normal. It's not the best, especially with such a sensitive issue. And it looks like 7-day deletion is in direct violation of state law, possibly federal law too. So how do we work that out?
Again, we see the information is retained into other sources, so it's in compliance with the law.
So it's interpretation.
Senator Barrett?
Thank you. And I apologize because I have to leave for session here in a second. But I wanted to say I worked at the polling booth last year so that I could kind of see what happens and how it works, and got to deliver the stick turn it in at the end. It felt kind of like Mission Impossible for a minute. Very fun. But I got to say that the poll book, the electronic poll book, was phenomenally helpful to be able to. Probably the thing that happens the most in Election Day is people are in the wrong precinct. And you just look it up and you tell them where they get to go. I mean, it's that easy. From a consumer benefit perspective, that's huge. It just gets them through there and out of there fast. And there's other benefits of the poll book, and I found it, the person that was our lead and our clerk absolutely love this system. So, and I know there's always opportunity for improvement, but we should be really proud that we've moved to this new system and it works really, really well. Thank you.
Senator Tice.
Thank you, Mr. Chairman. Representative Bolin, did you have something you wanted to say first? Okay. You referenced metadata that was retained in QVF but not on the paper copy. Can you elaborate on what metadata specifically you mean?
So I'm trying to think of how to explain it. So I think that gets to Representative Johnson's question. Like it's like that timestamp stuff. It's the back end of when things were entered, that piece of it is the best way I can describe it. When you print it, that doesn't print as part of, I'll equate it to a Word document, 'cause that's the best way I can do an analogy with it. When you print a Word version, you don't always see Adam Fracassi made this change, basically. That's all part of that metadata piece. So that's what gets preserved as part of that upload and not on the paper. And I hope that answers your question, but if not, let me know.
That helps. It helps to define it. So ballot number, which would not be retained on the ballot, so we wouldn't then know how they voted. That ballot number, is that part of the paper copy or is it part of the QVF?
I believe it's both.
Okay.
I can't remember the paper version, but it's maintained. I can check on that and follow up if that's helpful.
My other question that I spoke to earlier is something that I would very much still like to understand. Why you can't go back to a particular date and time and say, what did this file look like at this date and time? And that seems like QVF should be able to do that. If it's not a function of QVF, it most certainly ought to be. Speaking of timestamps, I think it's very relevant information, particularly given the information that we've been informed that people have been put onto the poll books that should have never been there. Non-citizens, for example, I want to know whether or not on this date and time that person was listed as a valid voter in the system. You should be able to go on this date, on this time, were these people there? If they're not there now, you don't know. So to my point, if QVF doesn't have that functionality, we certainly ought to figure out how to make sure that it does in the future. Thank you.
Is the timestamp foiable?
I would have to check. I can't remember off the top of my head.
Get back to me on that, will you? All right, Rep. Johnson. Oh, what, hang on. Rep. Boland's got to leave, Rep. Smith's got to leave, so I'll excuse them, but
Thank you. Thank you. Thank you to the members of the committee today and for listening.
okay, Rep. Wertz.
Thank you, Chair. I've got one other question on the rule proposed 168.45. It says if a polling place has internet access and the Bureau of Elections has established live connectivity functionality with the qualified voter file, the electronic poll book software used on Election Day must have a secure live connection to the qualified voter file software to allow real-time updates to voter history and ballot issuance. Explain to me how you ensure that it has a secure live connection. It says it must have.
So essentially, that's how. So at the high level, that's how our EV poll book works now. You have to have that air-gapped connection, so that way it can't be penetrated by a third party. It has to make sure that I will say there's a number of security features, both from the Department of Technology Management and Budget. So what that rule is trying to say is that if you don't meet those requirements, you can't use it. You have to do the paper backup. You've got to do the download and the paper copy as your backup. That's essentially what that rule means.
And who is it a software company you guys use to ensure that is that secure live connection? Who did you use this last time for that, for all the early voting? How did?
DTMB. The poll book's developed by DTMB in conjunction with the Bureau of Elections specifically.
Okay, so DTMB, I guess, data tests or assures that live connection? And have there been cases where that has been penetrated, whether here or in other states? Because I assume they're doing this in other states, or are we the first to do this?
They aren't. There could be other vendors, but this was our Department of Technology Management and Budget built this specifically for Michigan.
Oh, the department built this?
Yes.
Correct.
That DTMB.
That's interesting. Isn't it very interesting, since we couldn't complete disclosures in a timely manner with that program, but this is, you're saying lock, tight, and barrel secure.
Well, we had several thousand disclosures all completed within a timely manner for our filing that just happened for August.
Oh, we had to extend 30 days because the system wasn't up and running for us to do it by May 15th, so it was extended to June 15th.
You extended it. It was up and running.
Not really. Tried several times and it wasn't on the website.
We're going to disagree.
Okay.
That was also not a DTMB product.
But
Then-
DTMB's not been penetrated, you're saying? There was no record in the last election of any insecurities, and it was fully secure?
I not that I'm aware of, at least, correct. I can't speak to any other part of DTMB, what they manage, but I as far as the poll book itself goes with the early voting poll book, that's correct.
Thank you.
Senator Runstead.
We've got session starting, but in order to preserve privacy and FOIA rights, how about combining the early and in-person voting, since they're both in person, so that we have that information, and then alternatively, if they're, rather than saying we're not going to give this data regarding how they voted, we're going to remove all that, because there could be somewhere in one precinct, one case where there was one voter, just excluding that one case and then providing all the rest of the information. I don't know if there's ever been a case of one voter in the precinct, but if there ever was, okay, there's a legitimate reason, but that doesn't seem to square with removing all the information in case there was ever a case where there was one voter.
Yeah, so here's the problem that I can't figure out how to get past. The problem is, and the reason why we landed on everything is because we don't have it broken down at the local level. So what comes to us and what gets reported to the state election data-wise are only races at the state canvases, and that is certified by the Board of State Canvassers. So in that instance, for example, it's school board races, right? Those are wholly canvassed by the county boards. They're run by our county clerks. That data never gets uploaded to us. That data never comes to us. So where the problem runs in with the method of voting in particular is there may be 50 people that show up on election day that vote for president, but there's drop off the further down the ballot you go. So when you get down to those races, we don't know whether or not. So the only way that we would be able to do that and to be able to compare it would be a manual comparison across all of the precinct by precinct results that we don't have for these elections. So that's the problem. I can't figure out how to. I have not so far been able to figure out how to accommodate that, to be frank. I remain open to ideas. I really do, because I understand the need for this data. I have worked through several scenarios with both political parties, to be frank, on trying to figure out the ways, and I have not been able to come up with a solution that gets us down to that level.
Thank you.
Okay. One more.
Thank you. FOIA. So if the local clerks delete this after 7 days or whenever they delete it, what happens to that process? Does it have to go to Bureau of Elections? Is it centralized in FOIA? Does it increase costs for the person requesting FOIA? How does that work?
So local clerks keep the paper. They can provide the paper poll book when they have it. That would be subject to the cost under FOIA as I can't remember the exact statutory language, but it's the lowest paid individual who's capable of performing the task, like whatever that task is. For the QVF upload, we do request that come to us because of the security and the cybersecurity pieces that we pull back that would basically, that if released, could jeopardize the security of the poll book itself and the qualified voter file and data information. So we have a report that we run that provides the electronic copy of everything, but strips out the cybersecurity piece of it. As far as cost goes, I don't believe there would be a cost difference between the clerk versus us. It's a standard report that's relatively minimal for us to run. I don't know the exact number off the top of my head, but it's pretty similar to all the other reports that we provide on a regular basis under FOIA, under QVF, from the QVF.
And I should say that that would be the same cost if you were requesting the same amount of information from each of us. Obviously, if you're a fuller look at the QVF from us would be a different cost. But.
All right. Last question from me is in the rule itself, Section 8 or Section 1, it says the electronic poll book software and associated files must be deleted from all devices by the 7th day. What does that mean?
So again, that's kind of what we've been talking about. So the poll book software goes onto the computer itself. So what that rule says is you've got to take that software off of that computer. So that way because if you can't have two versions of the same thing at the same time, that will cause problems and you won't be able to open the polling place, to be frank.
Associated files doesn't mean the download or the paper?
No, correct. That's correct. That still has to happen. And other sections of the rule say you close the polls, you print everything off, you maintain all of that with the paper poll book that goes to the local clerks for that 30-day or 22-month storage. You upload it to QVF, which gets maintained, and then you take that copy, that copy that you have basically, and delete that piece of it.
Yeah,
but you still preserve those other ways.
Yeah, that part of the rule might need a little clarification. I want to get to the other people that want to testify today. Thank you. Very informative. So if you're going to stay, it'd be great because some of the other people might have questions for you after this. All right? Thanks a lot.
Thank you.
Okay, first up, submitting a card, Timothy Smith. Go ahead when you're ready.
My name is Timothy Smith. I'm the Republican candidate for Secretary of State. I'm here today because Secretary Benson's proposed rule set violates both federal and state law. It threatens the integrity of our elections and strips citizens of their rightful oversight. Rule 8 specifically requires the destruction of electronic poll book data within just 7 days of certification. That directly conflicts with federal law requiring 22 months of retention, Michigan law requiring 6 years retention, as well as federal audit requirements. Destroying election records is not just reckless, it carries criminal penalties under both state and federal law. By eliminating this evidence, the rule undermines voter roll maintenance, it prevents meaningful post-election audits, and it silences legitimate citizen oversight. We're already facing serious concerns in this state with thousands of ineligible registrations, deceased voters in the voting rolls, and voting history records that change. This rule would hide the very data needed to investigate and correct these problems. This is about accountability, transparency, and rule of law. No Secretary of State should be allowed to override state and federal requirements in order to conceal evidence, shield themselves from scrutiny, and control the election outcome. If we allow these rules to take effect, then we, the people, will lose our voice. Secretary Benson's actions are destroying the very foundation of our republic and placing Michigan on a dangerous path. I urge this committee to fulfill its constitutional duty and reject these rules. Our republic depends on preserving election records, not destroying them. Thank you.
Thank you, Mr. Smith. Shelley Lake.
Good morning. I had a whole speech written out. It's out the window. I can barely contain myself here. I also have part of the testimony from the transcript where Jonathan Brader was cross-examined in Hillsdale County. Very enlightening. I used to have a lot of respect for Adam Fracassi because I FOIA'd clerks for QVF data, simply who's registered in your township. They've been getting memos from Secretary of State or the Bureau of Elections saying, don't release this data. You got to get it from the Bureau. Regulatory manager at the time, Adam, sent back to the attorney a memo saying, absolutely, release the data, redact what you need to. I really respected that. That's gone. So, yes, federal and state law, deleting EPB data, that's my heartburn, you guys. And this isn't going to sound professional because I haven't written this. I have FOIA'd clerks across the state for EPB data. I'm a deputy clerk and have ran elections on my own when my clerk has been absent. I can tell you what's on those flash drives. Exists nowhere else. It is not uploaded. Let's see. When I FOIA EPB data from my local clerk, 2 out of 14 in my county gave it. The rest committed felonies and deleted that data because the Bureau told them to. As of today, I have not filed criminal complaints, but I'll tell you what, my patience is gone. Gone. Being told to commit felonies, but they've done it. But so I FOIA'd EPB data from the Bureau and from my local clerks. Nothing matched. Voter IDs, not one matched. Timestamps from the Bureau said 0000. Everyone voted at midnight. They were gone. Timestamps are FOIAble. They are not listed in items legally to be redacted. They removed the method of voting because they know what the local clerk gives us, EPB data, and what the Bureau gives us does not match. The method of voting is important, and it's not listed in what needs to be redacted. They know none of this stuff matches. I feel for our clerks, I really do. They're in a tight spot. They're being threatened, harassed, charges brought against them. Stephanie Scott in Hillsdale. I have attended her hearings. Mr. Brader admitted he doesn't know what's on those flash drives. He's not a technical expert, he said. He also admitted that the Bureau's directives to clerks have been unlawful. And yet they continue doing it. And then they bring it here, and you don't have a quorum, doesn't matter. You don't have 3 and 3, can't vote anyway. Bureau's going to do what they want. They're going to create laws to delete EPB data when it's clearly against federal and state law. I'm just dumbfounded. There is no confidential software on these EPB drives, okay? I've seen them, I've downloaded them, I've looked at them. It is really easy to redact what you need to redact and fulfill these FOIAs and not commit felonies. Flash drives, under $10. We don't delete our data. I tell you what, I'd rather pay that $10 myself out of my pocket than risk going to jail. A couple other quick things. Everything, he says everything is printed, everything is not printed. The clerks are constitutionally elected officials who are custodians of their own documents. The minute they upload that data and they say, oh, it's in the state's hands. What about chain of custody? Gone. How hard is it to take that little flash drive, put it in your closet, lock it up? Everything is not uploaded to that QVF. Let me see. Yeah, no, there's no confidential software in those flash drives. The other thing the flash drives show is when the pings happen. Pings after pings of people trying to get into they don't want you to know that.
Can you wrap up?
I can. I tell you what, I will email the entire testimony from, with Jonathan Brader and my statement that I didn't read. And I know you guys can't do anything, but this is incredibly maddening that the Bureau is able to get away with this. Thank you.
Thank you. This committee will go at ease. Committee's back in session.
Not in session, not in session.
I thought we came back in session so I can make an announcement. And then I'm going to go to E's.
It's just an announcement.
Okay, just an announcement. All right. So we have some administrative rules, and we have a committee coming in at 10:30, so we've got a hard stop now. All right? And we stay at ease? And we're going to stay at ease. Thank you for everybody that's shown up, and we might revisit this another day. Thank you.